Good morning. I still have some people joining, so give us a few minutes before we actually get the program going today. So just as a disclaimer, normally this is the second Monday of every month, but because of Martin Luther King holiday last week, we did move it to today. So it's the third Monday in January. And so there may have been a little bit of confusion on the links to get registered for today's program. And so we do apologize if there was any confusion. I know both Felicia and I attempted to get the updated link out to everyone today. So welcome, welcome, welcome. And again, always thank you, Felicia and Menta, for giving us your time, your valuable insight and knowledge, and making this such a learning experience. And so I know that you mentioned in our pre-start here that we have a number of new people in school districts, and so I'll let you just say a few words to welcome them.
Well, I just wanted to welcome those. I tried to send it out. We have some new work comp reps and some new risk representatives working at the schools and in HR, and there's a lot to learn, as you know, so we're going to try and kind of keep up. And I love that this week our superintendent, Dr. Gotthold, just sent out it's Acts of Kindness Week. So I also just want to say how much I appreciate working with the schools, and I love my job.
Well, wonderful. Well, your passion is certainly evident, and I know that because when we've known each other since the early 90s, and the early 90s are going to be very important as we get launched and talking today about two key laws. You know, what we said we would talk about today are three key areas. A closer look at ADA, FMLA, workers' comp, ed code, and as many of you know who participated in our IPMs, they overlap, and so in significant ways, and it can be a confusing muddle, particularly to the employee with the medical condition, who oftentimes is their first time ever being exposed to this. And so think about where you are in your careers and how confusing things can still be, and imagine being that employee for the first time coming into an IPM. So we're going to take a closer look at that. And in our preparation, Felicia has found a wonderful real-time life story going on right now that isn't even fully resolved. So you'll get firsthand insight into what EEOC, Equal Employment Opportunity Commission, is thinking. And then also, COVID is still with us, not maybe as rampant as it was back in 2021 and 21-22, but it's still with us. And so we're going to touch a little bit on some updates with AB 2963. And then also we're going to, with what time we have, at least a glimmer into what to expect with a fitness for duty versus a qualified medical examination, whether it's the PTP, the QME, the AME, all of those little acronyms, maybe some of you may not even know yet, And so want to touch base on that because we are seeing much, much more happening in the return to work efforts with the use of fitness for duty, and it becomes very important. And I'll share with you my recommended strategy for how best to use that, and that's based on my many years of working with EEOC decisions, guidelines, and things like that. So that's where we're going to head, and whatever we don't get to, we'll roll over into February session. And just a reminder, the program is being recorded, and for all of you who have registered, you will receive a recording link, so you can go back and listen and view the program again. I like to say repetition reinforces retention, so spending a little time to do that would be very helpful in helping you learn. But we also provide very important links. We've got an FMLA cheat sheet, so to speak, as well as a link to the AB 2963. So we usually get that out to you within about 3 to 5 working days, and so do watch your inboxes for that recording when it becomes available. And of course, it's always retained on my YouTube channel, where you can subscribe and be notified of future programs coming up, but also on my website. And so for many of you, you know about the interactive process web page that I have. That's a good resource to share with employees coming into the process for the first time, as well as other participants who may not be familiar with the process. And just, 2023 is all about a new look, new branding, things like that. So I do plan to update that video because it is a few years old now. Not that anything's really changed, but time for a new look. So let's get started, and we're going to kick it right off, Felicia, with sharing the story that you have found, because it illustrates so well some of the missteps that people can make when we're handling employees with medical conditions. So take it away.
Great. Thank you, Deborah. So this is a fictionalized story of a real case that's been dramatized a bit for effect, and it's all dealing with the question: if an employee exhausts all their FMLA leave, are you obligated to grant additional time under the ADA? So I'll go into our story. Can you tell me what's happening with Mina Cruz? She's suing, asked Eric Bressler, company attorney, stepping into the HR manager, Lynn Rondo's office. For what? Lynn responded. She's got an attorney who claims she could have gotten more leave under the ADA, Eric said. I don't see how. Mina had a shoulder problem and took 12 weeks of FMLA to recover from surgery, Lynn said. She got the full 12 weeks. When her leave ran out, she said she needed 3 more months to recover, so we had to terminate her, per our policy, Lynn continued. Everything was in order with her paperwork. She even signed off that she understood we only give 12 weeks of FMLA, no more. Sounds like we were more than fair with her, Eric said. It's unreasonable for her to think she was entitled to 3 more months. We did our duty, and we provided Mina 12 full weeks without any problems, Lynn said. If that's the case, we're going to fight this, Eric said. Lynn's company fought to get Mina's disability discrimination lawsuit dismissed. It argued that it had granted Mina's FMLA leave in full and was not obligated to give her any time outside of that. Did the company win the decision? No. The company lost in court and is now waiting to hear how much Mina is owed in damages. This is an actual case, but they haven't come out yet with the EEOC decision. The company argued that it had already fulfilled its obligation to Mina by giving her 12 weeks of FMLA leave. It also said Mina signed off on the FMLA policy. But the court ruled that despite what a company's policy says, additional leave under the ADA must be considered when a disabled employee exhausts his or her FMLA time and still needs additional time to recover. That's as long as the added leave won't create an unreasonable hardship. So the court looked at whether the 3 additional months of leave Mina requested would have caused undue economic hardship on this company. The determination: the company was used to high turnover rates, so it could have reasonably accommodated Mina by keeping her on an unpaid reserve roster until she recovered. The analysis: ADA leave must be considered as well as other leaves, including FMLA. Policies that automatically terminate employees for not returning to work after exhausting their 12 weeks of FMLA leave without taking ADA leave into consideration are being shot down left and right in the courts. Bottom line, leave policies must leave room for the ADA accommodation process, even if it means employees get to take more than the 12 weeks allowed under FMLA. So that's my story, my real story.
And so what went wrong for this company? First and foremost, rigid mindset, rigid policy. And for those of you who worked with me, you've heard me say many times is that the EEOC, while we have guidelines, and it's important to follow those guidelines, we also need to look at the circumstances of each and every case on a case-by-case basis. And so flexible thinking is really, really important in taking a look at the circumstances of any particular case. And I'm just looking around the room, and I can't imagine, maybe except for a couple of you who we've been through this rodeo many times before. And we've had employees who've been off far longer than 6 months. And so I want to reiterate a couple of key things. the EEOC has long said that it's not easy, but most employers can get by with an employee off of work for 90 days, hence the FMLA. And then again, while not easy, allowing up another 3 months, like in this case, is also reasonable. Not easy, but reasonable, in order to give the employee an appropriate amount of time to recover. And so many times then that so 180 days is sort of the standard maximum leave that is to be considered. However, again, we have cases that go beyond that. And that's oftentimes a lack of management on the part of the employer in terms of really tracking employees and looking at the hardship that might be created. And then the other thing about that is that there was another ruling that, and I'm sorry, I don't remember the exact citations, but I believe it was within the last year, that the EEOC has said that if an employee needs additional time beyond the 180 days, and it's finite, it's discrete, like 30 days, maybe even 60 days, that is permissible to go beyond whatever stated policy and the maximum timeframes, because again, it's concrete. Indefinite, ongoing, undefined leaves of absence. If a doctor says, I don't know when the person can come back, that's not something that you have to accommodate. I believe the case that I was referring to was actually in the spring of 2020, I think. And it was a UPS case. And the policy was that if you're off of work for a year, you're terminated. And that's not unreasonable. But in this case, the employee came back and said, I need another 30 days. And the employee said, too bad. We've exhausted our policy. And so they lost big time. So this is where, again, taking a look on a case-by-case basis, a lot of these timeframes are bargained at the local level as well. And many situations, school districts have 120 days maximum as bargained. And so, Felicia, you want to comment a little bit more about that?
Well, the one thing when I was reading through this case, the EEOC always makes notes at the bottom, things to watch out for. Mm-hmm. So I think employers must give consideration to the full range of options under disability guidelines and not just go by work comp statutes, or not just go by ed code statutes, or not just go by, you sort of have to look at everything holistically. And that's what I think is so great about everybody coming with questions to you and I. We have this situation rather than just jumping in and saying, nope, sorry, there's nothing we can do, because there are other statutes that need to be considered, right? Mm-hmm. And there's a lot of different timelines, right, between the workers' comp. And so that's why we do think that looking at each case, yes, you have your policies, and then looking at each case, and lots of districts have some flexibility with their unpaid leaves that can be requested and approved, and with their catastrophic leaves that if they pay into that can be requested and approved. So kind of using those things as a guideline too, I think can help.
Okay. Yeah, definitely looking at some past history becomes critically important. One of the things that I'd like to comment on that a lot of people are not familiar with is that, in 1964, that was landmark legislation when we had the Civil Rights Act. And that identified 7 areas of protected classes, race, age, ethnicity, religion, disability, and a couple more. And what happened after the Civil Rights Act passed is that then we began to see a series of legislations evolve over time that further defined each of those areas. And it took until the 80s, actually, for the disability feature to really get examined. Actually, we had the 1973 Rehabilitation Act that provided educational opportunities for people with disabilities. But it wasn't until in California, I think it was 1988, that the Fair Employment and Housing Act was passed. And then the Americans with Disabilities Act was being worked on, but signed into legislation in 1990 under President George Bush. And I happened to be very fortunate. I was president of the statewide Rehabilitation Association, and so was very, very involved in the rolling out of the ADA and how it impacted employees with work-related medical conditions. And was fortunate enough to actually meet one of the I don't want to say founders, but originators of, maybe that is the word to use, that helped draft the language for the ADA. And so, so that happened in 1990, and the employment provisions of that act really kicked into place in 1992. Interestingly, the Family Medical Leave Act actually is something that evolved over time and was passed in 1992. So it's coming up on its 30th birthday. The ADA just had its 32nd birthday. And a lot of people don't know this little tidbit is that the Family Medical Leave Act was actually sort of crafted in order to address fathers' rights around pregnancy. We had pregnancy, acts to protect the rights of women taking leave for pregnancy purposes. But it was found that that was actually sexual discrimination because the father's rights were not addressed. And so that's really how the FMLA started, was to address fathers' rights around pregnancy. And but as we now know, evolved to consider any the individual or immediate family members who had medical conditions that impacted their ability to be at work and provide protective leave. And so just some interesting facts behind those two laws.
I do think I want to add something to the question that you asked me about the 120-day or 100. Some districts have 120, some employers have 180 days of temporary accommodated duty before they're permanent stationary. When that elapses, and they usually are sent home either on sick leave if it's non-industrial or on workers' comp TD 2/3 if it's a work comp claim, it's important to keep track of that case. The one thing I do see some districts, this happens sometimes, they're counting very closely on that 120-day or 180-day of their policy. Where they lose track is when they go off completely and they're either sick leave notes or they're over in workers' comp getting work comp notes. You still have to track the disability to see where you are. And when you're getting close to the end, way before you get close to the end of leave, we need to start talking about meeting. We need to start talking about the importance of attempting to find a reasonable accommodation. Do we need permanent work restrictions? Do we need to go to the doctor and ask for permanent work restrictions? We actually have to be proactive when we know we're running out of time and saying, oops, out of time. So sorry, you've exhausted all leave. And basically, you're going off of your off payroll. And the one thing that the EEOC did add in a note I was looking at is that it's the employer's duty to trigger the interactive process, even if nothing has been said, but the employer notices that the employee is struggling mentally or physically performing at work.
Yep.
That's really high bar, right? Without
Yes.
a vote, right?
Yep. I'm so glad that the EEOC has made that emphasis again, because quite frankly, that emphasis has always been there. And so, I've been at this, as you have, for many years. Was already working with employees with medical conditions for work-related purposes in the 1980s, as you were. And then when the ADA rolled out, then it certainly broadened the scope and rolled into the world of non-work-related medical conditions. And again, having done this kind of work for many employers at many different levels, EEOC has always said, if you see a change in behavior, in workplace performance, even though they've not said anything, do activate the interactive process, because it could be that something medically is going on. And so the idea is, how do we restore this employee to full performance of their essential functions with or without accommodation? And that there's a couple of things to be said about that then, is that, the goal under the ADA is to keep people working. The goal of FMLA is, when people are unable to work due to medical reasons, is to protect their job rights. And so right there, they have different purposes. And so again, it's how to manage those then. And in the bigger picture, to emphasize what you had to say, Felicia, as far as, tracking these cases, and earlier intervention with an IPM is much better than late intervention, because the idea of these laws is to help people keep working, to minimize the impact socioeconomically. And I've done a lot of research around this, because it ties into the Department of Labor and all these different other laws we're not even going to get into. But the idea is, from a socioeconomic perspective is to keep people off disability if they can work. And so that's where this whole idea about being looking at accommodations and so forth. And so often I know what happens. Well, one thing before I go there is think about temporary accommodation, again, within the timeframes you have versus long-term accommodation. And those are two different concepts. I'm not going to go into much detail right here, but a lot of model employer programs identify temporary opportunities in other departments where they need help, provided they can do the work medically. And so that keeps them in a pay status. You're getting productive work out of an employee rather than sitting at home. This is whether it's work-related or non-work related. And so developing a bank of temporary jobs where there are needs, and particularly with the shortage of employees that we've been seeing, particularly post-pandemic, that help can be very valuable. And I know one of our employers here today is doing a great job of that. Congratulations, Sweetwater. And keep that up. And so it really is, again, a different way of thinking. Now, the other thing I wanted to say about that is too often, and Felicia, I want you to speak to this more too, too often employers think that workers' compensation is the driver of somebody's time off from work when it's a work-related injury.
Right. So it's the intersection, and we do a lot of training with payroll and with the work comp reps to help with this, right? Because while we're doing salary continuation, and I still think of the disability as a person with a disability, regardless of the comp injury, right? Mm-hmm. I just think of the comp injury as like a side note almost, right? The disability came first, and I don't care if it's industrial or non-industrial, still needs to be tracked, still needs to be counting, and we still have to begin the IPN process if it's clear the employee's having difficulty with their time and attendance or with their performance, or if an accommodation is needed. And sometimes we're asking that, right? Rather than waiting for them to come to us. We wait a lot of times for them to come to us. Workers' comp knows very little about the ADA and FMLA and disability discrimination and the civil actions that can occur. They have a different set of laws that they're operating under. And frankly, the litigation on the civil side is so much greater than the litigation on the comp side. I'm always much more worried about what are we doing on the return to work area. The workers' comp case I'm not saying that the TPA will take care of the issues with that, but they are not responsible for return to work. They are not responsible for finding the person to work. And to your point, a lot of the districts have been getting really creative because we're shorthanded in lots of different areas in taking the injured workers, whether out on a work comp injury or the sick, and filling in for all of the when they're qualified, of course, you know, and using those to fill in the holes because we're short on subs also.
Yes, so. Absolutely, yes. And so I know that's you know, we could talk on and on, Felicia, as far as some of the nuances and discrepancies. And so I do encourage our viewers and listeners to, you know, jot down any questions that you might have and feed those back to us, because there's so much depth that we don't want to overwhelm you with where we could go and go off on a sidebar or sidetrack, et cetera.
I think it's a mistake to wait. I think it's a mistake sometimes to wait for the PNS when it's taking forever. I think it's a mistake sometimes to wait for a QME that's going to take 3 months. Somebody the other day was telling me they have 2 doctor's notes that conflict. They're going to wait for the AME report. Okay, that hasn't even been scheduled yet. That's going to take 3 months. I was like, no, I would meet on the 2 reports that you have, try to find out, get clarity. Let's see what we can do. Waiting that amount of time while all the time is running through isn't very productive. And work comp goes slow. It's just slow. Right now we're having a hard time getting people in. We're having a hard time getting med-legal appointments. We don't really want to wait. So let's meet. When in doubt, let's meet. Even if we don't have everything we need, let's meet and talk, and then we can keep talking, right? But at least we're interacting, because we're not going to get anywhere waiting. So, no.
And just going back to something you said, you know, there's that the litigation is far greater in the ADA arena than in workers' comp. Yeah, and so adding to that, just to be clear, is litigation under the ADA is far more costly. The punitive damages are significant, and not to mention lost wages and all kinds of things that can happen. And so it's pretty tremendous. And that takes me back, Alicia, I know that you probably can talk better to this, is that the case that came out last fall with the school district up in Northern California. And maybe you can just identify a little bit about that.
Right. Well, it was a really unusual case because the applicant or the plaintiff in this case brought a civil action against Keenan, who was the broker TPA, and against the school district, which was, I think, Santa Cruz school district was involved in this case.
Right.
And Santa Cruz settled out of the civil case. I think they paid $1 million to settle out on a return to work issue where the employee felt he was wrongly terminated. And then the TPA, broker TPA, decided to litigate and then got, I think it was a $34 or $35 million judgment against them because of what the jury found and the jury verdict. And they're appealing that case, of course, but it was a cautionary tale, right? That you have to be very careful how these return to work issues are handled.
Yes. Yeah. And so interesting. I think we're seeing more cases like that surface too. And I'm not quite sure what's triggering that, because in some respects, the law hasn't really changed so much. There's been case decisions, because of litigation, but the law is still pretty much the same it's always been. And so it always amazes me, particularly in the private sector, how, like the case that you outlined in the very beginning of our program today, is that, people just not aware of this intersection and application of these different laws. And so we're seeing a lot more educational opportunities out there as well.
And before we move on, I just want to add that we do always recommend, not that I'm an FMLA expert by any means, but that we do recommend that when the first day off work in a work comp injury for certain, that when work comp begins, work comp TD, and they're off work, that you start FMLA right from that point. We don't want you to get through later on in your time and be exhausting time. And then, oops, we need to activate the 12 weeks of FMLA.
Yeah. Yeah. Too often employees will wait till the employee asks, well, employees don't know about all these laws. It's a pretty savvy employee that will know what to do. And so it is, again, the employer's job, HR's job, to reach out and pay attention to those kinds of things. So broadening the bandwidth, right? Yes. Yeah. Well, let's go ahead and let's shift. Again, I'll just acknowledge we are going to send out this FMLA cheat sheet, and then moving on to AB 2963 and what's happening, looking ahead to COVID protections. So
Governor Newsom approved AB 2963 on 9/29/22. And AB 2963 is the COVID notice requirements, and that has been extended. That was set to expire on 1/1/23, but that has been extended for COVID-19 protections until 1/1/24. And that law includes the posting notices in an area visible to all employees, as well as notification of potential exposure of employees that might have contracted COVID and where they got it, and the tracking of COVID cases and the timelines for requiring you to report to the local Department of Health. It's quite lengthy, so I think that's why I'm going to have Deborah actually include the wording. I just wanted you all to be aware that that was extended, and we do have to comply with that through 1/1/24. And we also, Governor Newsom's presumptions, SB 1159, that COVID-19 is presumed compensable, which did a few things, right? It shortened the time frame that we have to investigate whether or not what we call delay and investigate a COVID-19 claim to see if it's compensable or not. And also the reporting into your TPA portal of any positive COVID-19 cases within 3 business days. That also was set to expire on 1/1/23, and that has also been extended to 1/1/24, and that's AB 1751. that is extending the protections of the COVID-19 presumption statute. So just wanted everyone to be aware of those changes. And then, of course, you guys all know that the California 2022 COVID-19 supplemental paid sick leave law expired 12/31/22. I have seen anecdotally San Diego County office extended theirs voluntarily. Don't have to do this. They extended their benefits of supplemental paid sick leave through January 31/23, and people have to start taking sick leave February 1st for COVID. But a lot of districts are expiring, and as of 1/1/23. One thing that's important to note is that employees taking 2022 supplemental paid sick leave for COVID, as of 12/31, could have continued to take leave they were entitled to, even if it extended past 12/31. And any employees that were entitled to leave in 2022 can still request pay from their employer or file a claim with the Labor Commission. So even though it's sunset, leave that is within last year can still be discussed and requested and paid. It just has to be within the last year, unless your district or your employer voluntarily is going to extend it. In talking with some of the districts that are extending it, they're concerned that they're going to get more work comp COVID-19 claims filed because there's no longer the 40 or 80 hours of supplemental paid sick leave. So that's a decision and a strategy that each individual district and employer has to go through.
Okay, so still some uncharted territory, so to speak, in terms of figuring out some of these nuances. And yeah, anytime there's a change in guidelines like that, some people will take advantage of it and some people won't. And I'm not saying that in a negative kind of way, but just that some people will know about it and some won't. So yeah.
I was looking at an article last night in preparation for this. I always do a little study and research. And this is a Harvard study that was done, that the costs of COVID-19 keep climbing. And per the article, long haul COVID-19 could end up costing the economy as a whole over $3.7 trillion. And on a yearly average, the medical costs for individuals who are diagnosed with long haul COVID is around $9,000 a year. So some people it was less than that, and some people it was more than that, but that's about the average. So I thought that was interesting, because we do have some teachers, we have some certificated and classified employees with long haul COVID. And it's really been tough to treat, tough to get better. They do get better, but it seems like it's slow. Recovery is slow, and they don't go back to normal. They just don't. So it has been a conundrum.
Yes. I've been hearing a lot too of different residuals that continue to persist, not to, cause them to be absent from work, but just, changes in physical behavior that are affecting people. Yes. Well, in our remaining 10 minutes, or less, about 10 minutes, let's go ahead and talk a little bit about fitness for duty and the whole qualified medical exam kind of thing, and the differences of when to use and when not to use.
Right. So I'll speak to, because we have a lot of questions about dueling medical reports, right? So we have a primary treater that says they can go back to work, and then we have a QME that says they're permanent work restrictions, or the primary treater said they can't work at all, and then we have a QME or an AME report, a med legal, that says they can work with permanent work restrictions. Two reports don't jive, right? So usually what we recommend that you do is meet right away. If you have a conflict, try to get to the bottom of it so we can fix it, because it takes a long time sometimes to get clarity. And so what the districts always ask is, what's better? Is it better to get a fit for duty for clarity, or is it better to wait and get a QME, AME through the work comp process for clarity? The one thing that's really need to make clear, fit for duty doesn't live in the work comp world. There's no opportunity to get one. They don't pay for it. They can't look at it. They shouldn't even see it. Shouldn't be even sent to them. That is outside of the work comp system. So the work comp system has to do the QME, AME process, but the employer can certainly, if they need to get clarity, even if it's a work comp case, you have the option of getting a fit for duty. The district arranges the fit for duty. picks the specialty of the fit for duty. It's paid for by the employer. The report goes to the employer, not to the TPA, not to be shared with anybody over in comp or the panel attorney or the attorney that's on the file, the defense attorney. The report goes to the employer, still medical confidentiality with that report, of course, and with the bill, because employer paid for it, they arrange it and they pay for it. And that report is limited in scope, does not have all the information that a QME report or an AME report would have, not even. It's narrow focus. Can they do this job? Review this job description. Is it safe? Are there limitations? Can they work with accommodation? What work restrictions do they have? That's what that report is really addressing. Stays away from all, and also it says next steps. If they feel some treatment needs to be done, they're just very careful. And fit for duties should be done by doctors that understand fit for duties, because they have real legal implications. You shouldn't just use anybody. Not just any work comp doctor can do a fit for duty, and not just any group health doctor can do a fit for duty. They need to understand it's a legal type of report, and it needs to be done properly. When you think about the work comp world and you think about primary treaters, the claims examiner at your TPA or your carrier arranges those. They pay for those. They are not sent to the employer. They should not be shared. The only thing the employer is allowed to have in work comp is, the diagnosis out of that report, the work restrictions, whether they're temporary or permanent, and the next appointment. You can have those things. Not allowed to know what medication they're on. You're not allowed to know a lot about their background or their medical history or treatment and all of that, because that's confidential. That's what happened in the case with the 30. There was some problems with medical confidentiality being kept. When you think about the QME AME process, who does that? The attorney, the defense attorneys arranges, or the state sends a panel. The QMEs have to be certified by the state. The employee can select, or the attorney can select through a process that we have. What QME is chosen. An AME is agreed upon by the parties. When I say the parties, I mean the TPA claims examiner and the attorney, not the employer. The employer does not participate in that. And then the attorney agreement, and it's paid for by the TPA or the carrier. It is not sent to the employer. It's sent to the attorney and the TPA with a copy of the bill, medical confidentiality rules in the QMEs and AMEs. So that is why we're so careful, and we only provide limited information.
Excuse me. I know sometimes when we talk too much, we get a little dry mouth there, dry throat. Yes. While she takes care of that, I'm going to ask then, knowledge on the fitness for duty. I see there is a question. In what situations can the employee request a fit for duty with legal justification? Excellent question. And so, as I put in the chat a moment ago, again, the terms of QME and AME are workers' comp only. And keep in mind that those doctors' evaluations are there to try to resolve the workers' compensation claim. How much permanent disability is there? What limitations? And all that, is rated by the state. We sometimes use that information from QME or AME reports on the return to work. But you as an employer are not limited to that. And this is where, you could actually get into trouble by waiting so long for the workers' compensation process to resolve it. So the fitness for duty is a tool the employer has a right to use to clarify return to work opportunities, readiness to return to work, safety, direct health or direct threat elements. And the EEOC has said that, first, turn to the employee's primary treating physician for guidance. But again, a lot of physicians, as we've already said, do not understand the world of work. And because they're there to do their specialty, they're there to treat their patient for their condition. They really don't know how to answer a lot of questions around return to work opportunities. And that's where you as an employer have the legal right to direct, let me start over. You have the legal right to direct your employee to a fitness for duty that you pay for. Okay. Now, EEOC does recommend, and this has always been the case, that you first reach out to the employee's doctor to see if they can give you guidance. And a lot of doctors, because they don't know the world of work, will decline to comment.
Right.
And then you've got a clear pathway to set up a fitness for duty, et cetera. And so, like Felicia mentioned, a fitness for duty has a very narrow scope, in that it's only about the return to work aspects. It has nothing to do with any workers' compensation claim, just return to work aspects. And that's why it's very important to provide, the evaluating doctor, the treating doctor, with a job description. Any comments or observations that you've had about an employee's behavior, difficulties in performing the job that Felicia referenced earlier. Those are very helpful to doctors in terms of, well, why is this an issue? What's going on? Because oftentimes the job description itself doesn't tell, it tells us what the essential functions are, but it doesn't tell what difficulties an employee may or may not be having. And so a fitness for duty, again, is narrow scope. It can generally get set up fairly quickly within 2 or 3 weeks. I'm working on a couple right now. And
yes,
and
they're faster than QMEs and AMEs too. QMEs take forever. QMEs right now are taking 2 to 3 months from the date of the appointment, and the reports are coming in 60 days, sometimes later, sometimes 90. We just got one 6 months from the exam date. They're behind. The doctors are very busy right now. Francisco asked a great question. Does the JPA offer fitness for duty services for non-industrial? So yes and no. I, as well as Dr. Dupree, I know the doctors that will do non-industrial fit for duty, and they have certain pricing that they will extend to our members, even though our members pay for it, because they do a lot of work with us on our MPN and the work comp side. And Dr. Dupree also has its services to help with the whole fit for duty process. So I'll let you go into that a little bit.
Sure. Yeah. One of the, I said in the beginning, I would share my recommended strategies. And so I see many times an employer, rushing to do a fitness for duty. And it's like, well, and they may reach out to me to ask for some help. And it's like, well, wait a minute, what's the context here? What's the whole picture here? And as Felicia said, we need to take a more holistic look at this because of the different laws involved. And what's the big picture here? And what are the concerns here? And so what I recommend that you do, and you will protect your legal obligation under FEHA and ADA right from the get-go, is, again, if you have concerns, if there have been reports from others, if you have observations of difficulties in performing the job, not being able to attend work on a consistent, predictable basis. There are more, but those are key factors. I recommend, and again, you'll be complying with ADA and FEHA immediately, is that you schedule an IPM. Meet with the employee, let them know about this bigger process, what their rights are, where they are with sick leave, where they are with the 100 days of half pay under Ed Code, et cetera. Help them understand why you're doing this. And again, their obligation is also under the law to comply, to participate, to engage with you. And so when you have uncooperative employees, the IPM is a perfect way to get started. And again, you automatically meet your compliance issues with ADA and FEHA by holding an IPM. By holding an IPM, then now you have a foundation that you can forward to the fitness for duty evaluating doctor. You're giving some context. And so that's something I do offer to assist, again, to all of our JPA and non-JPA members. And it's usually a nominal fee, quite frankly. And the cost of a fitness for duty, I have jokingly said to recently, it's like, too bad we're not in Imperial County, because they cost a heck of a lot less over in Imperial County than they do in San Diego County.
Cheaper, right.
Yeah.
We do. And we do have an hourly rate, to answer, Francisco, to your question specifically. We have an hourly rate with all of our occupational providers in our contracts for non-industrial fit for duties.
Yeah.
And all of our occupational medical providers do have some doctors that do fit for duties, but not all of them do. So it's good to reach out to myself or Deborah when you're trying to figure out who to send them to. And the one thing I wanted to add when I was talking about the differences, the one case where the employer, this is a school district, and they've got two reports that don't make a lot of sense from two different treating doctors. And they wanted to go to an AME to resolve their differences. And that is going to take 3 months, right? We don't even have the date of the schedule exam yet, let alone the report. So I told them it's 2 to 3 months out. And they were like, well, they're running out of leave. So that isn't going to work as a solution. And so you're right, going to the primary treaters and trying to get clarity, or looking at the option that could be faster, right? Because we can go talk to that doctor and say, hey, can you please help us? They're behind and sometimes aren't super a quick response right now, but it's not going to take 3 months to get a response from them. And we can get a nurse case manager to go see the doctor to try and help get that what you need. But a fit for duty is always, a topic of conversation. It's always an option. Workers' comp kind of goes, what is that? Right? Like, because that doesn't live there, right? You have the right to get one if it will help you.
Yes, absolutely.
Get in comp.
Yeah. And not to mention, my experience is that we can oftentimes get someone scheduled within 2 to 3 weeks. And the evaluation is typically 2 to 3 hours in duration. And I have actually experienced where I've gotten the evaluation report back within 1 to 2 days. I mean, that's how fast we can generally turn it around. And so we can make decisions about the return to work possibilities much more quickly. And particularly if we're talking about benefits running out, the 100 days running out, things like that. Because again, we want to try to avoid by our own inaction, forcing employees into an unpaid status. When we talk about scary and talk about what will drive litigation is that, when they feel they've lost their job and they burn through all their benefits, those are the kinds of factors that tend to trigger employees seeking legal representation to take it to the next level. And guess what? You probably won't stand up very well if you haven't done your job on a timely basis. Right.
You want to do everything you can to try to reasonably accommodate everything that you can, right?
Yeah.
So that it looks better to go back to our story at the beginning, right? They didn't do very much, right?
Yeah.
Not a lot of looking at all the options.
Yeah. And to emphasize the point you made earlier, Felicia, the employers looked at as the big brother. You should know better. You're the one that has the training in human resources and risk management, all these laws and things like that. It's your responsibility as the employer to be proactive and to initiate these things on behalf of your employees who don't know about all these different laws and what their options are. So I see what we are closing in on the time for our program today. I knew we had a lot to talk about. And again, I encourage all of our participants here to, think about what you've learned, what questions you have. We had some great ones in the chat box. And again, there will be a recording released to all of you, along with a couple of resources, the FMLA cheat sheet, as well as the overview of the AB 2963. With that, I just want to emphasize then too, we'll be going back to our second Monday of the schedule, and you had the opportunity to pre-register for all of those coming up ahead. Can't make it, send somebody else, pass it on, share it with a colleague, share it with a friend, and we'd love to have you back and hope you find this valuable. Yes. Anything else, Felicia?
Just Happy New Year to everybody.
Well, I think 2023 is getting off to a great start, although a little cold. But I think it's going to be a good year. And looking forward to working with everybody. Thank you again, Felicia, for all your time and effort. I know you put a lot into researching some of our topics that we come up with. And thank you. Thank you, Victoria. We'll talk to you soon. Thank you, everyone. And we will see you next month, February, the month of love.
Yes, the month of love. Yes.
Okay. Take care.